Welcome. Good afternoon, everyone. I'm Keith Bybee, the Director of the Institute for the Study of Judiciary, Politics, and Media here at Syracuse University. And as you know, every spring we have a lecture series on law, politics, and the media that's co-sponsored by IJPM and the Tully Free Speech Center, directed by Roy Gutterman, Newhouse. The aim of this speaker series is to bring out a wide range of practitioners from the fields of law, politics, and media to reflect on issues that fit into the broad area of interest, the intersection between these. Today we're fortunate enough to be joined by the Honorable James Murphy, who is the coordinating judge of town and village courts for the 5th District, 5th Judicial District here in New York. Justice Murphy was elected to the New York Supreme Court in 2004. Before taking the bench, he served as a member of the Onondaga County Legislature. He's practiced law for a number of years. In fact, he was Assistant District Attorney for Onondaga County. The town and village court system here in the state of New York is not absolutely unique in its history, but it's quite unusual relative to structure of judiciary in other states. And it's been a subject of some controversy for, say, roughly the last, 100 years. 100 years. So Justice Murphy today is going to talk to us about the justice courts, as they are called. The title of his lecture is Justice Most Local, The Truth About Town and Village Courts. Please join me in welcoming Justice Murphy.
Thank you all for having me up here. That title sounds very ominous. I didn't know that was the title till lunchtime today. But in some ways it's appropriate. I know you've had assigned as reading the New York Times series. That's one of probably 6 different efforts over the last 100 years to do away with the town and village justice courts. Why am I here? Because of my position since 2006 as supervising judge, and also because, frankly, of my time as an assistant district attorney. After I left law school from here, I was fortunate enough to get hired by the district attorney's office and spent, if any of you are going to a district attorney's office, your first assignment will be justice courts if you're upstate, because they meet at night and they're all over the place. So I spent a lot of time in them. And frankly, I think that that's a very good system. I bring that bias to this position, and I think that's probably why they picked me for it. As the action plan, as you read it, and if you haven't read it, when you do, you'll see that most of that involves supporting the system, not taking it down. And because of that, I'm here. What I wanted to do just quickly is I have a 14-minute movie, if you will, or video. It was done by the State Magistrates Association, so understand they're the judges, probably around 1999. This is not high-definition TV, but I think it'll give you a flavor for them, and rather than have me lecture at you as to the scope and as far as what things they do, it shows a lot of pictures of courts around the state and different things that I think probably portrays a picture that I can't. So because of that, I'm just going to run that for 14 minutes, and then I'll come back and talk about some of the particulars. I'm hoping I'm going to run that. I'm going to turn lights down, please.
Hello? Yeah, what do you have? Okay, I'll be there as fast as I can. Sorry, dear, I have to go in for an arraignment. Glad to know the depth of your concern. Ouch! Why does he have to leave a basketball at the top of the stairs? Hello, docket, old girl. Now, don't get too excited. No walk right now. Maybe later. I've got to go. Now, where are those keys?
When our nation's founders developed the framework of our judicial system over 200 years ago, they could scarcely have imagined the challenges facing modern society. Yet, throughout our history, from state and national constitutions to landmark Supreme Court decisions, the judicial branch has remained a stabilizing force in American society. Nowhere is this more evident than with New York State's town and village justices. Every day, and sometimes night, these men and women make important decisions which affect the lives of thousands of our neighbors and keep our society, a society of laws, equally applied to all persons. Approximately 2/3 of the judiciary in New York State are town and village justices. Sometimes it is forgotten how crucial is the work of these public servants. They are many times referred to as the courts closest to the people, with good reason. Town and village courts have a very broad but limited jurisdiction in criminal, vehicle and traffic, and civil matters occurring within the boundaries of a town or village. They have trial jurisdiction over all misdemeanors, violations, and infractions in the penal law and other state and local laws, from arraignment through sentencing. In felony cases, including murder, rape, and robbery, the local court has arraignment and preliminary hearing jurisdiction. The case then goes to the grand jury and county or state court for trial. Justice Court has concurrent jurisdiction with family court on family offense and domestic violence situations. And Justice Court caseloads involve a multitude of other different laws and types of cases. The civil jurisdiction of the local court is limited by the amount of the claim and can be brought in either the regular civil or small claims court. A trial by jury is also available under certain circumstances in civil cases. As the National Task Force on the Administration of Justice in 1967 stated, these courts are lower only in the sense that they are the courts before which millions of arrested persons are first brought, either for trial of misdemeanors or petty offenses, or for preliminary hearings on felony charges. Although the offenses falling within the trial jurisdiction of the justice courts, predominantly misdemeanors or lesser criminal violations, traffic, and small civil claims, may appear to the casual observer to be petty with respect to the amount of money involved, or in relation to amounts in other courts of superior jurisdiction, the work of these so-called inferior courts has major implications for the citizens and families in the community. The casual observer may not clearly appreciate how these so-called minor charges could have emotional impact on the accused or the family. The accused may feel the impact of this one time in court for the rest of his or her life. Civil suits to the court's maximum jurisdiction or for a few dollars can be hotly debated. To the plaintiff, the principle behind the suit can be as important as the realization of dollars. The gravity of the charge or the amount of the claim can be secondary to the opportunity to air the grievance and to have a fair hearing of the issues. Town and village justice courts provide this forum in a timely manner, minimizing the costs to the participants and the taxpayers. The quality of life in the community is thus enhanced by the participation of the local town or village justice. Also of great importance, there is consistency in town and village courts throughout the state. In 1967, the state ushered the justice courts into the unified court system of the state of New York and established the one-court concept. The result was the adoption of uniform rules and practices. All citizens and attorneys, no matter in what area of the state, could have an understanding of the policies and procedures applicable in each justice court, because they were all the same. The accountability of the town and village court system is an essential feature for its continuing importance at the local level. All justices are required to keep accurate, legible records of all proceedings, and at least once per year submit case dockets for examination and audit to the town or village board. All justice courts must account for and send all fines and fees collected by them to the state controller by the 10th of each month. Where caseloads warrant, much of this work is performed by court clerks. The clerks also handle correspondence, prepare the court calendar, and even issue certain case-related court processes. Perhaps most importantly, the court clerk is the first person citizens will most likely encounter when making inquiries of the court. A pleasant, professional court clerk is an important component of the courts closest to the people.
These courts are the points of contact with the administration of justice of the overwhelming majority of the inhabitants who come into any contact with courts and court officials. There, the great bulk of the population receives its impressions regarding the speed, certainty, fairness, effectiveness, and incorruptibility of justice as administered. Cleveland Foundation Survey, 1922.
Some activists, reformers, and self-serving individuals and groups argue the justice court system is an anachronism, without place in today's society. The answer advocated by some is the replacement of town and village courts by the establishment of the district courts, funded and staffed by the state. Such courts were established by the laws of 1936 in Suffolk and Nassau counties. A district court may encompass several townships or an entire county. Some of today's advocates are locally elected officials who want to be free of the burden of funding and dealing with the needs of local courts. Partially born from a lack of understanding and appreciation of the contribution local courts make to the quality of life in the community, and partially for monetary reasons, the easy way out is for these officials to abandon their elected responsibilities by turning local judicial functions over to a state-operated court. If district courts were the answer to court reorganization, it would seem that the glowing benefits touted by advocates would be self-evident after over 60 years' experience with the district court system. The only 2 district courts established remain on Long Island. No other district courts exist in New York State as of November 1996. The taxpayers will foot the bill in either case. The question is, how large will the bill be? Unlike other courts in the state, the justice courts present a unique posture in that they presently do what prominent and contemporary reform advocates suggest be done by all courts. In a sense, they offer a challenge for similar reform in all other courts. The justice courts having achieved the following: individualization of treatment, informality, decentralization, diversion, citizen participation, reduction of backlog, cost control, and speedy trial. The unified court system of the state of New York has been conducting an experiment implementing the benefits of the justice court system within the city of New York for minor offenses. The Community Courts program locates courtroom facilities in the neighborhoods of New York City. The system provides for quick arraignment before a judge, who is on hand to follow the case closely from arraignment to disposition. Assembled within the immediate purview of the court are all the necessary components of the justice system. These include public defenders, prosecutors, probation staff, an array of alternatives to incarceration, and post-adjudication alternatives. Close inspection reveals interesting similarities between the new community courts and the justice court system. And yet, on a regular basis, the district court drum continues to beat.
Conservative political opinion in America cleaves to the tradition of the judge as passive interpreter, believing that his absolute loyalty to authoritative law is the price of his immunity from political pressure and of the security of his tenure. Learned hand.
Town and village court justices are local elected officials. Presiding on a part-time basis, they need not be lawyers, but they are nevertheless held to exacting standards. Justices must complete not only basic training, but also annual updated classroom training, followed by a written examination for those justices who are not attorneys. Furthermore, there are strict rules limiting the manner in which justices may campaign for their position, as well as their participation in local and national politics. These rules, combined with the ethical oversight provided by the Judicial Conduct Commission, a panel established by the voters of the state of New York by amendment to the state constitution to govern the behavior of judges while in office, help maintain the independence, dignity, and integrity of the court system. In the last 10 to 15 years, the passage by the state legislature of mandatory sentencing and fines has restricted the court's ability to make human, case-by-case judgments, the very essence of an independent judiciary. The duties and limits of the town and village justice courts continue to evolve to this day with each meeting of the state legislature.
Rigid justice is the greatest injustice. Thomas Fuller, M.D.
Not long ago, town justices were also members of the town board and played an integral part in the day-to-day operation of town government. Obviously, this system set up the possibility of important conflicts of interest. By 1977, following a constitutional amendment in 1961, judges had been removed from the town board, replaced with elected town council members. This change was essential in improving judicial integrity and the trust of all citizens in the system. But it did result in some tension between the judicial and legislative branches of local government, particularly regarding the funding of an independent judiciary, which is the responsibility of town and village municipalities. Often town and village courts are overlooked because of their minor work, settling traffic disputes or small disagreements between neighbors. Sometimes this work that is closest to the people has led local executives and legislators to regard the local judicial system as less than equal. This misperception is one reason town and village courts are often underfunded by the very municipalities that they serve. This underfunding can seriously affect the ability of a local court to keep pace with workload and carry out duties vital to the community. Local courts handle the largest number of cases coming before the state's court system and contribute greatly to state and local government. In 1995, town and village courts collected and sent to the New York State Comptroller's Office approximately $128 million. $58 million was redistributed by the state to the towns and villages. Another $11 million went back to the counties. The mandate of the judicial branch of government, whether the national Supreme Court or the smallest village court, is to serve the people by providing substantial, timely, and equal justice. To achieve this mandate, it must be given adequate, reasonable, and necessary funding. Only then can the town and village court system remain the separate, independent branch of government as set forth by our forefathers in the constitutions of the state and country. Only then can local justices truly remain the courts closest to the people.
A great deal may be done by severity, more by love, but most by clear discernment and impartial justice. Johann Wolfgang von Goethe.
Okay, now I know that's corny. But there's a lot of things in there that I think are important. You see from looking at the pictures that the difference in each of the courthouses and the difference in each of the courts as they've developed over the years, that's determined by local government, by local people as to how they want their court to be. It's also determined by population. That's a big issue. In going through New York State, I have towns that I see and I should qualify, I guess. I'm the 5th judicial district that I represent. That's 6 counties in upstate New York that basically from here to Oswego to Watertown to Utica and Herkimer County. You have everything in my district, and the state's divided into 13. I told you 12 earlier. I forgot Staten Island 2 years ago. They made us separate, so that's the 13th. There's 13 districts, and it's divided up. The largest town court is Clay, with 60,000 people. And I think the smallest, as best I can remember, is town of Montague up on the Tug Hill, where 90% of the land is state park land. They have 98 people. And they have a town and village court, although right now they're probably going to become one of the first courts or first towns in the state. There are 3 towns are going to consolidate their courts into one. Completely different concerns. That small town is overrun by snowmobiles in the winter. They have probably more snowmobile and park-type tickets than any place else in the state. And they deal with everything from every person on the East Coast. Other places, Clay probably has very few snowmobile tickets. Pulaski has more salmon fishing violations and violations of the environmental conservation law with regards to fishing than any place in upstate New York. These are all different, and I think the problem, at least from my perspective, in the issue that's arisen over the years is this attempt to try and make one court fit all, the one that we're all used to. Go into and you see some of the nice brick county courthouses, and that's what everybody's looking for. That doesn't fit, cost-wise and staffing-wise and population-wise. Coupled with that, for the last 100 years, has been, frankly, the legal profession's attempt and insistence that town judges and village judges cannot fairly administer the law because they're not lawyers. That's a debate that I know I speak to people in New York City who feel very, very strongly about that. Most of the attacks of recent in the New York Times article, subsequently adopted by the New York City Bar, come from New York City. There's no town and village courts there. They've never had a town and village court. In fact, I think it's very interesting that in this old movie, it is true that the community courts, which New York City now touts as being a great thing, went to neighborhoods, essentially dividing New York City into little towns and villages. So people didn't have to travel all the way across or all the way uptown to try and get to a court. That's the same idea of the town and village courts. Now, what's become particularly difficult in the last 25 years is this debate that has gone on about lawyer and non-lawyer judges has essentially been brought up and defeated by the New York court system. Court of Appeals decided in the 1980s, and the Supreme Court had decided earlier, that there's no constitutional violation for someone to have a pending criminal matter presided over by a non-lawyer judge. That was a split decision. Interesting to find out who's on the dissent. Saul Wachtler and Judge Kaye. The two past Chief Court of Appeals judges and Chief Administrative judges. In that capacity, they share in New York. If you're the chief judge of the Court of Appeals, you're allowed to pick the Chief Administrative judge. Judge Wachtler had picked Judge Kaye. Judge Kaye became, well, no, that's not true, but Judge Kaye then took over and she picked Judge Lippman as her Chief Administrative judge. He now has gone up to the Chief Judge of the Court of Appeals and has appointed Judge Ann Fowl as the Chief Administrative judge. The point being that for 25 years, the Office of Court Administration and the leaders of the court have not supported the town and village courts. They haven't done it monetarily, and I believe it's probably a unconscious bias. They don't believe and haven't believed in them. Now, that all changed in 2006, and to the extent that the New York Times article, which I think was a very sensational, and I know people are from the journalistic side of things here, I think that was a particularly one-sided portrayal of the town and village courts. You can, if you look at the article itself, written in 2006, going back into the 90s to try and find things that judges had done particularly wrong. There's let me get the numbers right. There's 1,277 justice courts in New York State. There's 2,200 town and village judges. Now, if you have to go back 10 years to find 10, maybe 15 that they specifically reference in there, without ever mentioning the other 1,980 judges or 2,180 judges, or the work they do, I think that's pretty shoddy journalism, in my opinion. It was not done to report on anything. It was done to make an argument. Now, good side is, and we all joked that the author probably got a speeding ticket upstate and was particularly miffed at somebody. But the good news is it forced the legislature, it brought at least this perception that there was a problem to the legislature, which was good for the courts because what do legislators do when they perceive a problem? They put money toward it. And that's really how I got involved. And I know you were assigned the action plan. The action plan is a response by the Office of Court Administration under the directive of Judge Lippman and Judge Fowl to respond in some way to the status of the justice courts. Each district was told to appoint a supervising judge. There also were positions added under myself in helping me as a law clerk judge that's a liaison between my judges and myself in the Office of Court Administration, and there's a support staff person. a lot of resources, and I'll detail them in a minute, we'll go through some of the summary of the action plan, were put to support the justice court system. That's probably the first time in 50 years that the state ever put money towards supporting them and stopped trying to take them out. Now, you can argue, and I've done it with people, lawyers, left and right, about the philosophy of whether or not there should be lawyer or non-lawyer judges. Again, as I say, the court has determined that constitutionally that's not a problem. But probably, in my opinion, more importantly, is 72% of town and village judges today are non-lawyers. They're up for election, and the people of this state, 72% of them, have said, it's okay with me that they're not lawyers. They run, lawyers lose to non-lawyers in elections upstate. And I guess if it's okay with the court and it's okay with the people of this state to the tune of 3-1, maybe somebody should stop arguing about that issue and trying to help the courts and support them. I think that's the action plan. The action plan was enacted and came out in November of 2006. I was appointed shortly after for this area, and we started to implement that. What does that mean? Full technological support for the justice courts. They were brought in to the court system, the unified court system. They were given email addresses. They were given Westlaw, Lexis, training and access. They have that at any time. That's one of the things I do. I've set up a network in coordination with the Supreme Court libraries of the bigger cities in my district. The Supreme Court librarians will give any judge one-on-one training on Westlaw and Lexis. And a lot of it, we have a hands-on system now that was never there. When a new judge is elected or appointed, I assign a mentor judge to them. They get their initial training. A lot of that's all been revamped. It's not like this anymore, thank God. There's a lot of web training and digital training, which was a big demand by the judges. Surprisingly, when the 2006 came out, I think a lot of the court system thought that the Magistrates Association, which is the state group, would fight them. And conversely, they welcomed them. They wanted training. They want to know how to do this. These are public servants. And if you don't get that, you don't get the town and village courts. If any of you were brought up in a small town, you know, I have college professors who are town and village judges. If you go down around the Ithaca area, there are a number of very well-educated people who are town and village courts. This is how this is how they help. They don't want it. There's some things they can do. They think they can do this. With the right training and things, I think they can too. It's a system that is very flexible. It meets the needs of a particular town and village without trying to staff or overstaff a court. And it is the court closest to the people, and I mean geographically. I was talking today at lunch about this notion of district courts is, and I think that's what, in 2006, what Judge Fow and Judge Lippman concluded, is completely unworkable in the state of New York and cost prohibitive beyond anything you can imagine. There's 2,200 town and village judges, 1,200 justice courts, 1,277 justice courts. That's by, I think there's 1,200 full-time state judges now. So you would be doubling the size of the New York State court system. And you would have to pay for the structures and the facilities, and remember those pensions that everybody's talking about now. That would all come into play. What bothers me most about it, too, is because money will then drive it, is there's no guarantee that every county gets a district court. Suffolk County and Nassau did because they're huge. You know, those towns are 100,000 people each. There's 5 of them. That population density doesn't exist up here. So in the course of a bad winter, if somebody's got to drive 100 miles to come to court, they're not going to come. And when they don't, what do? Suspend their license. Now, are they going to stop driving? No, because they have to work and they have to get their kids around and they have to carry on with their life. But now they're all misdemeanors if they get caught. That's a criminal charge of driving with a suspended license. So we made all those people criminals because we didn't want them to drive couldn't drive 120 miles an hour, 120 miles to get to a court. It doesn't solve the issue. One of the things too, and I know it seems funny, is that midnight arraignments. These judges get up at all hours of the night. I said that to a group of New York City judges. They thought I was crazy. They did not believe that. And I said, no, it's true. And they said, no, that's not true. When you come to court and it's 9 o'clock and the court starts, and I said, no. If someone gets picked up for a felony DWI or something at 2 o'clock in the morning, they do just what you saw in the first thing. The police officers have all the judges' names and they call them. Why? Now, is that a good or bad thing? Immediate arraignment. Don't have to lock anybody up, possibly, because most people get released on their own recognizance or bail. Sometimes they don't have ID on them. The police officers can't decide, and they bring them in, and a judge will ask them, where are you from? And a lot of times these judges at least know of these people. When they say, I work down at so-and-so's, they might have some familiarity. They release them. Taxpayers don't have to pay to keep them in jail overnight. Don't have to transport them with 2 officers, and not to even mention the safety concerns of the officers. They're only moving them 1.5 miles down the road, not 40 miles to get them to a place. And they won't. City of Syracuse, if you get picked up in about 20 minutes, you will be held till tomorrow morning. That's at a cost. Not a personal cost to you, because sometimes if it's an offense, if it's not a serious enough offense, they'll have what they call bench bail or booking bail, where they automatically, no matter who you are, bail's $1,000. So if you can come up with that, you'll be out. You'll be able to get out in a couple hours. Otherwise, you get arraigned tomorrow. All of those things, I'm not sure how that helps for the type of crimes and things that we're talking about. If you're out there hunting after dark, do you need to be locked up overnight? I don't know. If you're driving with a suspended license because, and I'd love to know how many people in here, you failed to respond to a parking ticket or someplace in Troy, New York when you were down visiting somewhere, and now if you look, there's a suspension on your driver's license. If you get caught driving, you're a criminal. So these courts, I think, have a very bad rap, and it's done by lawyers. It's done by lawyers who want to demean them because they think they're incompetent. And I think that that's very unfair. And in my view of the judges, I think they do a great job. They're public servants. Are there bad ones? Yes. There are bad plumbers. There are bad anything. One of the great things about the action plan when they brought up the technology, and I mentioned this at lunchtime, was there was no way to record the proceedings. So what does that mean from a legal standpoint? There's no way to appeal the proceeding. So if you're a bad judge and you know how to play the system a little bit, you can do things and maybe cover your tracks well enough so that no one will really catch up with you. Or if they do, they're going to have a hard time proving it. One of the first things the action plan did is the state provided laptops with spider microphones and their digital recorders. And Judge Fow issued an administrative order that requires all of those to be, every proceeding to be recorded. So if there's an issue, you have a copy of the CD, it can be appealed, and the remedy is to have it reversed on appeal, or if it's bad enough, to send it to the Judicial Conduct Commission. That was 5 years ago. Anecdotally, I had been told by county court judges and by the State Magistrates Association that there are very, very few appeals from town and village courts. Everybody presumed that that was because there was no record of that. 5 years later, there are still very few appeals from town and village courts. The issues that you read about and the problematic issues are issues that come up rarely. Most routine matters, we train them when they do. The same thing happens to judges, full-time judges. If there's a unique issue, you need to get help, guidance, research. That's what you do. when things come in front of you that you've never seen before. We provide that now. This cell phone, every judge in my district has this cell phone number. The judge who helps me, Judge Gideon, who's a town of DeWitt judge, he also has a cell phone number. There's a resource center that's been more fully staffed that's in the Albany area that has essentially 10 lawyers there to help the town and village judges. They call me. Fortunately, they have very good judgment. They call me in the evening, but I've had a couple really crazy things happen. You get a call and they can't get through to anybody until at 2 o'clock in the morning because they've got somebody trying to execute an extradition warrant. And if you haven't seen one of those, I didn't know. A lot of it's just technique as to how to get around that. Some of the judges get very nervous because they are non-lawyers, and I don't think that helped. I don't think it matters, but the non-experience is more important. Lawyers come in and make some argument to them. It sounds ridiculous, and they don't know what to do. Now, when lawyers do that to me, I say, counsel, that sounds ridiculous to me. So I'm going to put this on tomorrow morning at 10 o'clock, and I would expect a brief from you at 9 telling me what authority you have to do that. I mentioned that at one of the first trainings we did, and a couple of them said, we can do that? I said, sure. The lawyers don't control it, you do. But they've never been told. They've never been told and how to do these things over the years. They struggle. They know the law, and they can do that, but of course that's the easy part. It's applying the law that becomes the hard part. And most of it is doing justice. I had someone say due process we talked about is, how can these lawyers comply with due process? How can these non-lawyers possibly do that? Due process is fairness, notice and an opportunity to be heard. I will guarantee you that any one of my judges, if somebody comes in front of them, gives somebody an opportunity to be heard. I cannot guarantee that about all the city court and county court judges who get a little fed up and irritated and probably overworked and burned out, who don't let people talk necessarily all the time. So it's not a lawyer, non-lawyer issue as far as my opinion. I think it's a training issue, and in the case of some people, it's an ethical problem, in which case they need to be dealt with. And that's also another area that the CD or the recording helps, because we're able to get a hold very quickly of a CD. And of course, now if they say, well, I didn't use it, you can probably get away with that once, because then I'll be all over you on a training, and we'll have people there to teach you how to use it, and you can claim that you don't know how to do that. Second time, you're in direct violation of Judge Fowle's order. So now that becomes an ethical issue, and you could be brought up before the commission and possibly thrown off the bench if they believe that your conduct was unethical. But I think we've come a long way. What other things have we done? The JCAP grants, I should point out, Justice Court Assistance Program grant. The state now is, and I say now, not knowing what they're going to do today or tomorrow, but the state has, since this, put $5 million towards helping courts improve their facilities. That includes security audits, which security is probably woefully inadequate in most of these places. They've gotten away with it for years, just like, they've never had a problem, so you go along saying we've never had a problem. But there are pretty good security issues when it's 2 o'clock in the morning and it's a domestic dispute and you're arraigning people and family members are coming down and no one's there other than you. It's probably a great exercise in your people skills to get out of there without having any further problems. But the courts are not funded well, and that's an issue that's going to have to come up through the town and villages. Consolidation and sharing of services is a big issue now. That's being looked at. But that's different than a district court. I mentioned the 3 small towns up at least in the view of the Office of Court Administration. These 3 towns are deciding that it's in their best interest to put a joint facility essentially on the border of the 3 and share the cost of that facility and come up with their own arrangement where that will work. No person really will have to drive farther than across their own town to get there. The 3 towns, the voters of the 3 towns have to approve that. And our position at OCA is that if the voters can do what they want, if a village wants to do away with its court, the town has to take that over. If two towns want to consolidate their courts or share a facility, that's fine, because the voters of those two municipalities have to decide. But we're absolutely opposed to anybody from the state, whoever that is, the legislature, someone trying to mandate this, because that goes against the will, I think, of 72% or more of the people. People don't believe in district courts. I just want to define numbers because they were so outdated. In 2010, the town and village courts collected $250 million. Seems like they could get a little back from the state, and they do. The states, they split that 50-50, roughly. The states gets $120 million, the localities get $120 million, and the counties get $10 million, which really has to do, I think, with Stop DWI stuff. I think that's why the only reason the counties get it is there were some designated funds there. I don't know if I said this, they hear nearly 2 million cases a year. As far as, I got the education training. Oh, auditing and financial controls is another thing that's really been a problem because of the nature of the system. You saw it in the movie. It's typically just a very nice lady who doesn't have a lot of experience in bookkeeping and all those sort of things, and therefore the records are pretty bad. Now, the problem with bad records is it's hard to tell when the records are bad and when somebody's stealing. And there's been those issues. We're working very hard, and we have since 2006 with the Comptroller's Office. A lot of that's being changed and is helped by the fact that the OCA and the state is buying them computers. There's now a lot of digital filing requirements, and that software is being provided, and as people are trained with that, it's automatically entered, and it becomes much more difficult for somebody to go around that. I mean, the programs are there. The comptroller is ready and expects it to be there. There's a lot of best practices that have been part of our education process to tell them what to do and how to do it. So I think we've come a long way. We probably have a long way to go. I think there's room for consolidation of services and shared services. It needs to be done thoughtfully and not, I think, knee-jerk reactions just because of New York Times articles and things. Because it really is a huge benefit to this state. I don't know what system the state would have to collect $120 million. It's certainly worth preserving since the people like it as well as the state because they get their money. I can't stay for that reception, so I'm going to stop now because I don't know if people have questions. I'm happy to talk to you about anything because I know I'm not going to. I apologize. I teach business law up at Lemoyne, and my class is at 5:30. So I'm going to do. I'll take questions if anybody wants. Yes.
You said that you feel like lawyers intentionally demean the justice court. I don't really see why you believe that lawyers are kind of conspiring to demean the justice court.
Well, because I think philosophically they believe that non-lawyer judges cannot fulfill the constitutional requirements that we have to make sure that everybody has due process, to make sure that people are assigned counsel, all of those sort of things. So I think philosophically that's a belief. I also think, I mean, I'm a lawyer, so I was in a prior life. Call it academic egos. I don't know. I mean, we all pay money to come to law school and come through here, so I guess maybe to some extent people are bothered by the fact that non-lawyers could do this. To which I say, I have lawyers who are very, very good lawyers. They're commercial corporate lawyers, and they do this because they run and become town judges. They know nothing about criminal law. They'll be the first ones to tell you that. They're the ones who call our office a lot. Now, they know enough to call, which is good, but also so I think that issue is something that I can't explain it other than it just always comes. And I guess the reason I generalize from that, because it seems like every attack against the town and village courts comes from the New York City Bar Association. And I don't know why that would be, because the New York City Bar Association does not practice in the town and village courts. So it's something to do with that. It may be that 2,200 of that maybe there's 30% jobs available. I don't know. But it's there, and it's been that way for 100 years. as far as that, and they're trying to do that. So I wish I had a better explanation for it, because I'm not sure people really articulate it. But that's the reality of it, is that that's where the attacks come from. Anybody else? Oh, come on. Who had a speeding ticket last?
I guess you could also argue that downstate attorneys also make the argument that if you don't go to a top 15 school, you can't practice law as well as, the Ivy League kids. So how do you break that stigma for the judges?
Well, I think the way you break it is to try and get a better perception. I mean, those articles like the New York Times, again, it was a mixed blessing, because I think it was completely inappropriate. However, it got more money, so I don't know. That's a weird, tortured logic of its own. But I think through education and through we've encouraged our judges to become more active and responsive to their town boards. Not just let them know what you're doing. Because for 20 years they were all told to not interact with the town boards. You saw that they used to be part of a town board, and then the law passed saying they can't do that. So a lot of them just distanced themselves from that. But you can't be distanced from the legislative branch. They have to at least know what you're doing. And the better public perception that is, I think, is hopefully education and maybe some unbiased media. You haven't seen the articles that I could show you about some really noteworthy town and village judges that are unbelievable people. You don't see that. I mean, the media just doesn't want to write about that. And yet, when they don't, then you're only getting one side of it. So, I wish that were the case. Yeah.
I'm wondering, I think that it's a good point that the closeness to the locality where the judges are working is a benefit. But could you also see it being potentially a negative? Because I think the New York Times article focused on kind of outsiders to the community feeling as though they have been wronged. So could you see that being also a negative possibility?
I think so. I think, one problem that the court, and that was mentioned in there too, and is something that the judges have to be aware of, is conflicts of interest. And that becomes a little more difficult. In some ways, if you're a city court judge, you have no idea who these people are. It's different in a town and village court. A lot of times you know who the people are. I face that because I was on the county legislature. I know a lot of people. It's just that's usually an individual judge's call as to whether or not you think it would, and there's ways around that. Again, you train them on that. If you have a question, you make both sides aware of that. Right up front, ask them if that's a problem. If it is, you have a companion judge, and you can move around that pretty well. But I think that's always going to be a concern. Not necessarily a bad concern, it's just one you have to be conscious of. And as far as the outsiders getting bad treatment, I don't know. Maybe that was the case years ago, but we have such a transient society right now. I mean, I talk to judges that if you're anywhere near around 81, you've met somebody somewhere in North America in the last week. I mean, you've met 15, 20, 30 people from out of state because of the traffic corridor. So I don't think that exists as much anymore. Might in some very, very rural areas, but usually very, very rural areas don't have big state highways. So there aren't a lot of outsiders. They're dealing with the local people. But it's something to be concerned about. That's always a concern. Anyone else?
Sure.
Yeah? Oh, sorry.
No, go ahead.
Go ahead, Jay.
So I always hear this distinction about laws, especially criminal procedure law in New York State. They'll say that there's an upstate distinction and a downstate distinction. 160-55, for example, sealing order law. And I wonder, is that related at all to the fact that, you see more of these kinds of judges upstate? I mean, is there any correlation?
Well, I think there's not so much statutory. There are some statutory exceptions or differences between upstate and downstate. There are a lot of administrative, and probably should be more, because one of the problems is trying to, I think, that notion of one size fits all, and we have to come up with a rule that covers Westchester County and Wyoming County. You can't. I mean, just the staffing and everything else, you can't. But they just desperately try, and I think there's a frustration that they can't come up with a single rule. But I don't think the statute doesn't have many. But I don't think that's. I think everybody's accustomed to their own procedure. So downstate lawyers who come up here expect to encounter the same procedures. And so when they're told that the court meets once every other week, that blows their mind, because this court is supposed to meet every day. So they get frustrated by that and immediately assume that that's inferior. It's just different, but in their mind it becomes inferior because it doesn't accommodate their schedule. They want to be able to come in there tomorrow at 10 o'clock, which you could do in city court. Or you know, they full-time judges are there all the time running calendars. You could probably call and ask to have it added or not. These judges work. I mean, they have other jobs. Most of them are self-employed in some capacity because it gives them that flexibility. As it's become more and more demanding, the flexibility to be able to leave and come as they go. Anybody else? Yeah, sorry.
Could you talk about when this responsibility as the coordinator was created? You were already on the bench, correct?
Yes.
So how did your job change, and like how did you fit this responsibility in? Why did you agree to do it?
My wife
Get
asked me
more
that.
money? I mean, you know.
No, I got no more money. My wife asks me that all the time. Because I guess I feel very strongly about this. I spent a lot of years in front of these courts, and I think our administrative judge was looking for somebody to do it, and I said I would.
And how much time of your time does it involve?
I have my same civil trial calendar. Nothing changes. It involves. It's hard to quantify because it comes in waves. It seems like. I may have to go away for a couple days to some conference. I do a lot of running around. The nature of my business is I do civil trials. I do malpractice trials, negligence trials, commercial trials, everything. The way we stack those up is Mondays, you show up to pick a jury if your trial's on. If it settles, I have the rest of the week a little more flexibility. I have motions and other things in there, but I can work around it. So I kind of keep this on the back of my list. I know that I have a problem in the town of Teresa up in Jefferson County, which I've got to deal with soon. And because they called me over the weekend, and I'm watching to see my schedule, and I will probably call them sometime tomorrow and see if I can run up there. I just, one big help is I do have this other judge whose sole responsibility, town of DeWitt Judge Dave Gideon, his sole responsibility is to help administer this, and he's much more. He's out all the time. I mean, but we just do what we have to. I mean, we have training sessions, and those you can schedule around, so I can make that work around my trial schedule. But no, I don't get anything more for it. Brownie points, I guess, at some point. I don't know, whenever that happens. But I really do believe. I mean, I think to some extent the New York Times article probably got me going more than anything. Is that it wasn't fair. It wasn't fair to all these people that I know to be very, very dedicated, good public servants, and to the extent that this was an opportunity to help them, it went back to my DA days, and I said I would do that.
Yeah, I guess just sort of jumping off that, I'm curious to know what your sense is of how differently the justice courts are operating now as a result of the action plan and some of these more recent reforms. And maybe just to add on to that, since the action plan, I think there were some other proposed reforms, particularly around consolidation. So I was interested in
Yep.
when you mentioned that consolidation is not the same as district courts.
Right.
But my understanding is there was a push to have some more systematic look at how things could be consolidated.
There
I
isn't.
was wondering, did that go anywhere? Is that happening?
Well, that's still going.
And
Let's
sort
say
of
this.
overall, how much is this changing the way the justice courts are, compared to 10 years, compared to when this film was made? How different?
If I can, I'm not sure. I can't quantify it in terms of we've got this many less appeals or this many problems less, but I know anecdotally if I talk to my judges, they're very engaged. They're very into it now. They felt like they were on an island cut off from the mainland, and now they're very active. One of the big things when I'm a big stickler on getting them all to use email, and that's not that easy. Think about trying to get your grandparents, a lot of them, to use email. But I'm a big stickler on that, and I've sold that to them on this network. We all rely on a network. The Court of Appeals judges do it. Everybody does it. If something comes in, professors do it. Something weird happens, you walk down the hall, and you try and find somebody that has encountered this before in any way. and you look for support and somebody to bounce something off. That's what we try and give them. That's what they feel is the biggest difference, is they now have somebody to call. They know that they can get Judge Gideon, they know they can get me. That gives them a sense of confidence. And a lot of times they don't call me in the night. I come in the morning and I got 3 calls. Because this is what happened at court last night. They're anticipating, which is great, where this is going, and are actively trying to figure it out. So to that extent, I think it certainly has helped them a lot. I don't know how to quantify that. And I guess I'm hopeful that, that over the period of time, somebody will be able to quantify that, because they certainly believe that. They're very much engaged in the network which we've created, because now you do have a judge, and if you're in one of the Finger Lakes communities and you get some sort of a salmon fishing or a fishing violation, by email you can contact the Village of Pulaski judges. And that's a pretty good thing. Big trucking things, that's all some towns deal with. If you border 81 or the Thruway or all those trucking regulations, which will just give you a headache. But if you're in a rural county, you may never have that. We're trying to get them out. We try and, through the Magistrates Association, get them to network, and that's been a big thing. The consolidation, every meaningful support of the courts, in my opinion, there's a lot of good ideas, but they can't get over that hurdle, because always the idea that seems to be leading the charge is get rid of the non-lawyers. Following that are 3 or 4 really good ideas, but we never can get past that. Now, age restrictions is something that's been talked about. I think the New York Times mentioned it, because there's no age limit on a town and village judges. So you can be 86. There should be. I mean, I think the state they got to look at is make the state 175, and that's what it is. Because that creates a problem. Like no different than trying to tell your grandparents that they can't drive anymore. I mean, they're up against retirement. These are really, they like what they're doing. They feel very strongly about it, and now somebody's got to try and tell. And unfortunately, usually the outside bad guy who gets to go talk to them about that, because nobody else has the nerve to tell them. But that's an issue. In the consolidation, the legislature doesn't engage anybody to act about how you would make this work. I'll give you one example. Village courts. In a lot of areas, village courts have gone away, and the town's taken them over. That should be a no-brainer to some courts, because the villages don't have that big a volume. They did historically, because that's where the crossroads were, and now as it's spread out, they don't. The state, by their laws, has a rule in there that if you are the village and you agree to do that, you give up your revenue. The very next year, you give up all the revenue from those speeding tickets and everything. Well, who's the idiot who wrote that? What village would possibly do that? In this time, whether you want to get rid of it or not, if you're making 20 grand off your village court, that's all, but you're not giving up that 20 grand. Why not just have a thing like they do in every other, they allow for municipal cooperation agreements that can go up to 5 years in duration. Why don't you let them phase it in? It's common sense things that, because no one asks in Albany, they just pass these laws, and then they're surprised that it doesn't work. Those laws towards consolidation have been around for a long time. There's a couple big impediments. Now, hopefully, we've created through the Office of Court Administration a legislative agenda. We're trying to identify some of these really specific areas. We're actually involved. The first one is this 3 towns up in the Tug Hill. We're hopefully that we will be able to transport that out as some sort of a template to 2 towns that really want to do it. I had to put on a conference to speak about that 2 years ago. Those laws for consolidation have been on the books for 15 years, maybe more. And I said, okay, well, I'll get as a speaker, I'll find the last municipal lawyer who did one. Nobody ever did one. That law's been around 15 years, and no one has done one. Now, that would lead me to believe that law is flawed. Albany doesn't see it that way. Now they do. I'm being sarcastic, but I mean, I think that's the point. And the reason that the consolidation has never gone anywhere, because consolidation means district court. And as soon as you say that, it's dead on arrival. The people don't want it. The town village judges don't want it, and therefore the legislature doesn't want it. So they have to get off these catchwords and start looking at substantively what they could change. Yep.
So, I emphasize and support to an extent the premise behind, the justice court system operating as close to the people as possible, like you mentioned, so that gets presented in the short clip. Being decentralized and being able to kind of weather the local needs and values of the community. But, my question to you is, what happens when there are cases of injustice, which we all know, does happen, or improper judicial etiquette that go unreported, or just inconsistent enforcement of the law? And, I understand, as you mentioned, which I'm sure you might bring up again, is that nothing in this world is perfect, and people make mistakes, but is it not a core value in America that we hold these different standards, these almost prestigious standards to our judges, that are arguably higher than standards we hold to any other vocation, including legislatures? So, we don't hold the same standards to judges as we do with plumbers necessarily.
Right.
And you and I would both agree that sometimes people's lives or the reputations that people have are at stake, and not just someone's kitchen or bathroom. But how do you address? How do you
You're absolutely right.
hold those same values that you mentioned on a community level? But
Well, no, I think you're absolutely right. The judges should be held to a high standard. Just before I went on the office, the answer is the Judicial Conduct Commission. I grabbed, just before, when I got back this afternoon after lunch, I looked up quickly some of their last decisions. And I think we'd all agree. Here's a judge repeatedly failed to advise defendants of their right to counsel and afford an opportunity to be heard. Another judge failed to timely decide 26 cases within 30 days. That's the requirement. Those 26 cases, the time ranged from 4 months to 2.5 years. Another one threatened a young lawyer with contempt if they didn't come back the next day and start trial. The young associate had been sent there to ask for an adjournment. The judge said no, and the lawyer, of course, panicked, saying, well, I just came here to get an adjournment. No, you be back here tomorrow, or I'm going to throw you in jail. This one, a cell phone went off in a busy courtroom. This judge had a very strict rule about no cell phones. One went off, and of course, just like we do in second grade, you say, who did that? And of course, everyone sat there and said, not me. Judge sealed the courtroom, sent 46 people to jail. Now, what's the problem with all of those cases? Those are all state-paid judges that I just read you. Family Court, Saratoga, Kingston County Courts, now Supreme Court judge, Supreme Court, Queens County, Family Court, City Court in Niagara Falls. So what you do is you punish them. They were thrown off the bench for that. And if you get one of my town judges doing that, then bring them up in front of the Judicial Conduct Commission and throw them out. And we now have a recording for that, and I agree with you. That should not be tolerated and cannot be tolerated. And I know last year, Bob Tembekshian talked up here. That's exactly what their function is don't protect them, but don't criticize them just because they're not lawyers. That's all I'm saying. Because these guys were all lawyers. These are all judges just like me that either got elected or appointed or somebody put them there. They're full-time judges. They got full-time staff. And that's what they did. And that's just me looking back quick. Now, another neat trick is a lot of these resign before they have a finding, and then it's sealed as confidential. But town and village judges probably aren't counseled well enough to know to do that, so they just go and say, well, this is what I did. What does that mean? And then they're admonished or censured or something for that. So I couldn't agree with you more wholeheartedly. I mean, yes, those systems our whole system depends on that. And that's why I find the New York Times article particularly egregious, because that played on those sentiments to suggest that our court system is not fair and just. And that's not true. If you figure out, I don't even know, I think he mentioned maybe I'm probably going high, 15 individual cases. That's less than 1,000% of those 2,200 judges. And if that's the case over the period of years he's talking about, that's the problem. But and that hurts that perception, because we all pay for that. Every judge does. And every judge, every time they do this stupid stuff too. You know, judges that are trying to do the right thing pay a price for that. And that hurts everybody's perception, and our justice system depends on perception. You're absolutely right. Yep.
We are out of time.
Oh, I gotta go, yep.
Okay.
Okay. Thank you very much.